This is Paul Turner, the Immigration Barrister at Imperium Chambers. Today I'm going back to the same subject of Balajigari, but in this time I'm going to be talking about the Court of Appeal and particular cases that are in the Court of Appeal. The reason for that is that today I received a raft of letters from the Civil Appeals Office with directions issued by Lord Justice Hickinbottom as to the disposal of cases that are raise the same issue of Balajigari and that are in the Court of Appeal. Lord Justice Hickinbottom has issued 6 directions in respect of these cases. The first is that the Court of Appeal will notify the Government Legal Department of all the cases that raise the Balajigari type issue, and they'll notify the Government Legal Department of that. Secondly, that the parties should get in touch with each other and should liaise as to the future conduct of the cases. What that means in practice is aim to get them settled. Thirdly, the Secretary of State should provide to the appellant, if it hasn't already, by 4 p.m. on the 15th of November 2019, a proposal for how the case should be dealt with. The Court of Appeal then give the appellant until the 13th of December 2019 at 4 p.m. the opportunity to respond directly to the Secretary of State to the proposal. And the order is quite clear that the response doesn't need to go to the Court of Appeal or Civil Appeals Office, that it needs to go to the Home Office itself. And penultimately, what should then happen is, but by the Friday the 17th of January 2020 at 4 p.m, the Secretary of State should notify the Court of Appeal of its outstanding position, and it should notify the Court of Appeal of which cases haven't been settled. And finally, the Court of Appeal will then issue such directions for the cases that haven't settled and are going to proceed. Now, what does that mean in practice? Well, in practice it means that the cases in the Court of Appeal that people have not heard from, or people have been worried that have got stuck, are going to become unstuck. And they're going to become unstuck because the Court of Appeal have issued these directions. And in short, the Court of Appeal are encouraging cases to settle and to ensure that that happens within a reasonable time frame. The Court of Appeal have given the Secretary of State until 15th of November to put forward a proposal for the settlement, and then afterwards individuals have then got a month to come back with a counter proposal, and then if agreement isn't reached by the end of January, the court will be notified of the cases where there isn't a settlement, and then the court will then issue directions. Now, what does that mean for an individual who has a case in the Court of Appeal? What should they do? Now, firstly, I would say that there's no need to panic. It means that the Court of Appeal are on top of this. But what it does mean is that by Friday, the 15th of November 2019, the Home Office should have contacted your representatives, or they should have contacted you with a proposal to settle the case. Now, if the proposal is a good proposal, such as withdrawal of the decision, such as paying costs, such as right to work or Section 3C leave, then that's the sort of proposal that most people are accepting. If that's not being proposed and there are issues such as costs outstanding, or the Secretary of State isn't making a suitable offer, then it's important that one works closely with the lawyer to get a counter proposal in to the Secretary of State by the 13th of December 2019. So really, the Court of Appeal is saying you've got a month, the Secretary of State's got time to get their act together, and then there's going to be a month for a period of negotiation for the appellants to be able to come back and respond and hopefully put the matter to bed. And then if that's not done, then the cases will proceed. So for individuals, I would say that what one needs to do is to make sure that you're in contact with your lawyer after the 15th of November, that you make sure that the lawyer has a suitable offer, and if you're not happy with the offer, you express the reasons why you're not happy with the offer, and ensure that your lawyer goes back to the Secretary of State with a counter proposal as soon as possible, so that hopefully the cases can be settled so that they don't come back to court. So it's good news that the Court of Appeal have issued these directions. What it does do is it sets a time frame so that hopefully if the Secretary of State plays ball and follows the position statement that it issued earlier as to the disposal of these cases, i.e. withdrawal of the decision, payment of costs and then reconsideration, if the Secretary of State plays ball, does what's said that they're going to do, then these cases should all be dealt with and disposed of in or around late December 2019. And I would say to any individual who has a case in the Court of Appeal that the crucial period is going to be from the middle of November until the middle of December to get the cases sorted out. And I say that because the last thing that I think will assist any individual is for there not to be negotiations and not for a suitable agreement to be reached. Because if there isn't an agreement reached, then it's likely that the Court of Appeal will set the matter down or will issue directions for the consideration of the cases. And that may or may not be in individuals' best interest, as the cases may be refused, they may not be refused, but it may have some impact in respect of costs. So there we have it. The Court of Appeal have now grappled with the Balajigari cohort. They've issued directions. It's quite clear that they want to see the Balajigari cohort that's in the Court of Appeal disposed of by, at the very latest, the end of this year or the beginning of next year. And so the matter, they can clear their decks and get on with other work. So I hope that this short broadcast has been of some use. Crucially, there'll be the period, as I say, between the 15th of November and the 13th of December for any negotiations to take place. And once again, I would advise any individual to make sure that they are in contact with their lawyer in that period of time, and that they make sure that their lawyer acts promptly so that their case doesn't proceed by default, which might happen if people sit on the file or work's not done. But hopefully that won't happen, and hopefully by the end of the year or the beginning of next year there'll be no more Balajigari cases in the Court of Appeal, and they'll all be reconsidered, and hopefully those that have got leave or entitled to leave get the grant that they deserve. As I say, I hope this has been of some interest. It's fairly topical, as I say, the letters only arrived this morning, but that's the purpose of these broadcasts, to hopefully keep you informed of things as and when they happen. Please do not hesitate to contact me, Paul Turner, the immigration barrister, on 0207 242 3488, or at clarks@imperiumchambers.co.uk, or at my site, the Immigration Barrister, on Twitter, if you've got any further questions or anything that arises from this particular video. Once again, thank you for watching. This is Paul Turner, the Immigration Barrister at Imperium Chambers.